Arbitration Life. I am Janette Brin.
And I'm Hana Doumal.
Globalization continues to connect people, businesses, and services across borders, creating increasing opportunities for international commerce. With this comes complex multi-jurisdictional commercial disputes involving different legal systems and sometimes different languages. International arbitration provides an avenue for parties from different jurisdictions to resolve their disputes. Parties can agree on arbitration rules to have their dispute arbitrated by an institution such as the BVI IAC. The new 2021 BVI IAC arbitration rules include new provisions for emergency arbitrator proceedings, expedited procedures, tribunal secretaries, joinder, and consolidation.
Yes, Janette, and the rules also reflect the Centre's commitment to encourage the adoption of environment-friendly measures in arbitration, including provision for the use of remote hearings, platforms, and electronic filing of submissions. Recently, the BVI IAC announced the new 22-member arbitration committee, 14 women and 8 men, drawn from the Caribbean, the Americas, Europe, Africa, the Middle East, and Asia. The committee is presided by Sean Gray, and we had the chance to interview her during season 1 of Arbitration Life. It will be the task of the newly formed arbitration committee to oversee the consistent application of the rules and to monitor their use in practice.
Now, our guest today is no stranger to the BVI IAC, being an advisor to the BVI IAC board. He is a barrister, advocate, and arbitrator practicing in London as a sole practitioner and in Singapore from Duxton Hill Chambers. He has argued hundreds of major international commercial, investor state, and interstate arbitrations, as well as groundbreaking cases in the highest courts of England, Singapore, Hong Kong, Pakistan, and the Caribbean.
He is a member of the bars of England and Wales, Singapore, New York, the BVI and Northern Ireland, and he's registered in the DIFC. He's the first QC to have been permanently called to the Singapore bar. He is a visiting professor at King's College London, a vice president of the SIAB Court of Arbitration. He's a member of the governing board of ICA, a fellow of the SIAB, and he was the UK delegate to the Institutional Working Group on Arbitration from 1994 to 2013. Among his many roles, he is a draftsman of the English Arbitration Act 1996, the Pakistan Arbitration Ordinance, International Investment Disputes of 2006, the Mauritius International Arbitration Act of 2008, and many institutional rules. Please welcome Toby Landau QC. Welcome to Arbitration Life, Toby. How are you?
Thank you very much. I'm very well.
Good. So Toby, I'm going to go ahead and get us started. Can you please share with us how you got started in international arbitration?
Happy to. I should say, first of all, that I come from a long line of doctors. So there was no law in my family at all. And there was profound disappointment when I announced that I was not going to be a doctor and that all the sciences were doing very well without my assistance. And so I turned to law at that point as something that I'd always had some interest in, but always international law, actually. I always thought that this was a way of traveling the world. And when I started to get into academic study, arbitration seemed actually as an amazing subject that combined contract law and international law and seemed very rich and something which I actually specialized in at a master's level. So when I started at the bar in London, I came already sort of immersed in the subject. And then really I was in the right place at the right time. When I started in practice in England, the government was consulting on a new arbitration act. It had been 10 years of great difficulty. They were inundated with responses, and they were looking for somebody young and available and cheap to be an intern to work on all this material. So I was actually seconded into the UK government to work on the Arbitration Act for a period of about 3 months. spent 3 months in a windowless basement at the Department of Trade and Industry, next to a sign on the wall that said, "Danger asbestos." And I stayed there for 3 months drafting. And when I finished that and was ready to come back to Chambers, I kind of had an arbitration label about me. So I had that specialty early on. And life at the English bar is very much about what you're known for. So if you do one case, your clerks will sell you as an expert in that case. And because I came with all this arbitration baggage, I was sold early on as somebody who knew something about arbitration, and then made my way in that field pretty early, actually. And I should say, very much with the help of some key mentors early on. Finding mentors is absolutely key in this area, and I was very fortunate on that score. So that was my slightly strange route into the area.
Very interesting story.
Yeah, that's a great start, actually. Very interesting route.
Yeah.
So Toby, how would you say arbitration has changed from the time you started compared to now?
When I started, I think it was a much more restrictive field than now. It was very much dominated by a small core of largely white, male, elderly practitioners. Not naming any names, but the average age when one went to an arbitration conference always seemed to be about 106. There was very little scope for people such as me to get into it, being young. It was very male dominated, very much dominated by Western European and American practitioners. And I think what's happened in the meantime is the field has grown in a number of different respects. So I think it's grown geographically. There are many, many more areas of the world that are now active in the field and have got active practitioners doing arbitrations on a day-to-day basis. I think the demographic has changed. It's become more diverse, much more diverse than when I started. The range of the subject has also changed. When I started, there wasn't any investor-state arbitration. It makes me sound like a dinosaur, but actually that's pretty recent. And what I think it's brought is a whole new area of practice of public international law, actually, and many different areas of focus that were way beyond the scope of arbitration. One's dealing with very sensitive issues now, all sorts of different types of sovereign discretion, and different types of subject matter. I think the field has also got actually more complex. There are many more courses now at university than there were when I started. Many more materials, many more books and journals, many more booklets with soft law in an A5 format with guidelines and protocols. So I think overall it's actually become, on the one hand, more open, and on the other hand, more complex and developed. And that's over a relatively short space of time. I've been in practice probably just about 30 years. So that's the change, I think, in that period.
Thank you, Toby.
Now, you obviously have extensive experience as a chairman, co-arbitrator, and sole arbitrator. What do you think makes an arbitrator a good one?
The answer, I think, lies in a number of qualities, and these are qualities that I've seen in other people that I respect. The first one, which is possibly controversial, is experience as counsel. I think there's a big difference when you appear in front of an arbitrator who has been counsel previously and one that has never been counsel. Not to say that you have to be counsel, but I think it adds a huge dimension in terms of sensitivity and understanding. If you've been counsel, then you know what it's like to argue a case. You know what the pressures are. You know what the thinking is. And sometimes I think people who have not had that experience are a little bit more detached from what might actually be going on in front of them. Secondly, I'd say less controversially, industry. That is somebody who is willing to roll up their sleeves and get into the detail. There is a slight problem, I think, in our field at the moment, that many arbitrators work with assistants and take on too many cases. There's kind of a business model, I think, now for full-time professional arbitrators. who like to take on as many cases as possible and can only do so because they have an army of backroom staff. And what that means is that they never really get into the case in the same way as, for example, they would if they were counsel. So the arbitrator who really will roll up his or her sleeves and will take ownership of the case early on, I think is the good arbitrator. And lastly, I would say emotional intelligence and interpersonal skills. There's something special about the arbitrator who can transcend just technical law and procedure and can actually warm up the room and warm up the parties and create an atmosphere of cooperation and collaboration and harmony. I think that's a very understated, often neglected quality. There are arbitrators who I would really respect, who have the ability to leave the arbitration hearing room with everybody feeling good about themselves and each other, and to render an award where the losing party doesn't feel so disaffected. That is incredibly important for the integrity of the process, but not every arbitrator has that quality.
Agreed. Very good point.
Yeah, very true. And we don't talk enough about interpersonal skills, emotional intelligence, but it's so important in our profession.
Yeah.
And people are not trained in that, of course. I mean, and that's not just arbitration. I'd say that's all legal practice. You know, it's a funny thing if you think about what it's like to appear in an arbitration, whether it's as arbitrator or as counsel. When you actually get to a hearing, you are thrown together in an interpersonal relationship with people in one room for an extended period of time, for extended hours, a lot of which you are sitting there looking at everybody else in the room and sizing them up and trying to understand them. I mean, it's just from a sort of social point of view, it's a very interesting anthropological experience. And you come away thinking, I like that person, I don't like that person, this person's irritating. And all of that is about emotional intelligence. And I think it feeds into the dispute resolution process in a way that people may not realize. Certainly as arbitrator, you can be influenced by whether you like counsel or not, or whether you find them irritating.
Yeah, very true, very true. And yet still be independent and impartial.
Absolutely. And sometimes I think these processes are not conscious, they may be subconscious.
Yeah, absolutely. No,
Yeah.
they are. So now, what would you say, Toby, that you enjoy most about working in arbitration?
I think for me, what is most fun about arbitration is diversity, cultural diversity. I have a court practice alongside arbitration practice. So I appear in court in many countries, mainly in England and in Singapore. And one does not have the diversity in either court system that you get in arbitration, because you're bound to one set system of procedural rules with an opponent who you will likely know with the same training from the same background, and a tribunal, judges, also same training, same background. When you're in arbitration, you could be appearing in front of a tribunal from all sorts of different backgrounds, completely different to your own, and with an opponent who sees the world totally differently from you. That gives rise to a rich cultural mix and the possibility of all sorts of different approaches, actually. You're not all set in one system. You can pick and choose. You have latitude. You can be creative in the way that you address the dispute before you. And that's something which is really what arbitration is all about. There is a flip side to that, which is a negative, and that is that the flexibility in arbitration can sometimes lead to a process that is flabby, that is undisciplined. And as counsel, that can be irritating because, or even as an arbitrator, there are times where you want the tribunal to step in and stop counsel because they're being irrelevant. And often you won't get that in arbitration because of the flexibility. So I often say to people that the best mix is to do both arbitration and litigation, and regularly to go back into a national court and get shouted at by a judge.
Yeah.
It keeps you on your toes, it becomes refreshing, and then you go back into arbitration sharper than where you were before.
Wow, interesting point.
Yeah, very true. No, litigation very much, experience in litigation very much feeds arbitration. So
Yeah.
absolutely agree.
Yeah,
I do
yeah,
miss
yeah.
courtrooms actually in France.
Okay.
The yell at lawyers.
Yeah, there's nothing, and also there's nothing like a judge saying to you, "You are being irrelevant. Tell me why this is relevant." I mean, that is a real or asking you a question which is incredibly pointed, a dynamite question. Arbitrators sometimes do that. And then as counsel, you really have the art of advocacy at that point to address it. But the most annoying is where tribunals don't do that because they're concerned about due process or appearing to prejudge something.
Yeah, but they're trying to understand. I say that because actually I had a case to Toby. He was the co-arbitrator. It was an exit case. I don't know if you remember. It was a hearing in London years and years ago. It was an exit case, so it's public. And I remember Toby asking questions together with the presiding arbitrator and the other co-arbitrator. Everyone was asking questions. So
yeah, and actually, as a counsel, that should be the best time because then you get a little window into what the tribunal might be thinking, and you've got an opportunity to really address it. Actually, the worst thing is silent tribunal.
Oh yeah, that's why mooting is so important.
Yeah. I mean, so you have no idea what is going on in their heads, if anything.
True.
And so it's difficult to know where to fire your shots.
All right. So Toby, you have a rather successful career, being the first QC to have been permanently called to the Singapore bar, a draftsman to numerous arbitration acts, argued hundreds of cases, inclusive of groundbreaking ones, let me say that correctly. What achievement are you most proud of?
I have to say, what I'm most proud of are the people who I feel that, the younger people that I feel I have been able to be a mentor for. There are many people in our field who have done extremely well, but they've built no particular legacy. But I benefited, as I said before, I benefited so much from a few particular mentors who inspired me and who have been a guiding light for me, even though most of them actually now have passed away. And what I feel proud about are the people who have said to me that they feel they've been inspired by what I've been able to do by way of guidance. In the end, things are come and go in terms of your own career. But when you can see that there are people who you have helped in their careers and they're shaping the field and they're actually doing work which is defining work, then that's something which I think one can and should feel proud of. And that's a sort of lasting testament that will, I hope, live long after cases that people will forget.
Yeah, thank you for that. Mentorship is so important.
Yeah, and you mentioned this, like, I think after the first question, and this is, yeah, something that we go over in Arbitration Life, how networking, mentorship, it's so important.
Yeah,
it's so important. And I'll name my key mentor that I'm actually keep referring to, and that's Johnny Vida. Johnny Vida from England, who I have a number of people who were very generous to me at the start, but Johnny was something very, very special. Unfortunately, he died a couple of years ago, far too early, but he's somebody who, for so many people around the world, was a defining character. Even people who only met him for a short time, but were inspired by him and thought because of him, they would go on and do something interesting. That is something I think to be proud of.
Yeah, absolutely.
Yeah, definitely.
So now, Toby, as a visiting professor at King's College London, would you say that your role as a professor enhances your work in practice?
So I have to be cautious in answering this because I've been a visiting professor for many years at King's College, but for the last few years, I have not been visiting so often, although I am still a visiting professor. So when I answer this, it will be, and anybody sees it who's at King's, it will be met with lots of complaints. But what I'd say is my work as a visiting professor is incredibly important for my work as counsel and arbitrator. There is nothing better as a test of your understanding of a legal principle than trying to explain it to a group of students, and especially high-powered students. It's something it's an experience that keeps you on your toes, and it keeps you current. And I've always had an interest in academic work. I think in our field, that is very, very important because it really actively enriches your work in practice, both as counsel and as arbitrator. And it changes your thinking. And it means that your thinking is tested by other people. So I've always enjoyed teaching, and I would highly recommend it to anybody. And I think through the teaching process, I have discovered areas that perhaps I never previously did understand properly.
Okay. So advice to all counsel out there and arbitrators, you need to teach, it's beneficial.
Yeah, I think so. I think so. And also you kind of build your own network of students that way.
Sure.
I think there's a gulf at the moment in our world of arbitration between academia and practice. They are, in a sense, two parallel universes, which is strange because the academic part of it is very practical, is looking at a practical subject. But many people are working in this field without really testing what they're doing with practitioners. And equally, practitioners often don't have that much contact with the academic side. And so much so that I've started this, I started something in London, which we've now continued in Singapore, which is a colloquium to mix academics with practitioners on a regular basis. And so this is a forum that allows academics to test their ongoing research with a bunch of practitioners.
Oh, wonderful.
And it's a very interesting synergy between the two. You get practitioners saying to academics, this is all completely unworkable. And you get academics showing up practitioners for being very narrow and limited in their powers of analysis.
Oh, great. When is the next edition of the colloquium?
Actually, it happens a couple of times a year, so watch this space.
Okay, great.
Yeah.
All right, so Toby, what would you say is the most memorable case you've had in your career?
It's a difficult question because cases come in so many shapes and sizes, and each one brings a different experience. There are a number of cases that I often talk about because they were formative for me. And if I had to choose one, it would be a case that I argued in the Supreme Court of Pakistan in Islamabad back in about the year 2000, 2001. And it was a case, a very well-known case between the Hub Power Company, Hubco, and WAPTA, which is a local water and power development authority. And it's memorable for all the wrong reasons. It was a huge case in Pakistan, very, very significant commercial case. It involved a power project, one of the biggest in foreign investments at the time in Pakistan. Power project had been cancelled. Foreign investors were bringing a claim against the state entity, WAPTA. And it was a claim that should have been in an ICC arbitration abroad. But the claim involved allegations of bribery and corruption against Benazir Bhutto, a previous Pakistan prime minister. The arbitration was enjoined by the Pakistan courts, so they issued an injunction to stop it. And the question that got to the Supreme Court in Pakistan was, can allegations of bribery and corruption against a previous prime minister be arbitrated outside of the country? That was the question. Very, very sensitive locally. It became a big issue in Pakistan. But why it's memorable is because in the course of the case, there was a military coup. The government became a military government. General Musharraf took over. And when we argued in the Supreme Court, we were arguing then against a military government. And the military government decided to do something rather inventive, creative in the courtroom, in the Supreme Court. They filled their side of the courtroom with generals in full uniform, long line of them. And those generals spent the hearing staring at the Supreme Court judges, standing up in the middle of my argument without any rights of audience, interrupting me and reminding the court how important this case was for Pakistan as a country.
Oh, wow.
It was an extraordinary experience of seeing an institution being undermined.
Yeah.
Unsurprisingly, we lost the case. And we found out afterwards that the military had been visiting the judges in their chambers separately overnight, putting pressure on them. But it was a very interesting experience to see how significant international arbitration can be in terms of policy, how we all take for granted court systems that work properly, and how a country such as Pakistan has recovered from that episode in the years since.
Oh, wow.
Yeah.
Amazing
I
story.
see why that would be memorable.
Yeah, absolutely. I cannot imagine like pleading and having the army and in the Supreme
Trying to
Court.
stay
Wow.
focused on your argument while these guys.
Exactly. And appearing in front of judges who themselves were being intimidated.
Right.
Yeah, absolutely.
So actually, we went through the motions of arguing the case and arguing the law. We cited a huge amount of law. In fact, amazingly, there were 5 judges, and there were 2 very, very brave judges who dissented. And when you look at the judgment that's reported, the dissent is a judgment of about 45 pages, citing a lot of cases. But the majority of 3 managed only 6 pages and didn't cite a single case. So it spoke volumes of what was actually going on.
Yeah.
And makes one grateful for court systems that we have, that we rely on without thinking about it.
Yeah, amazing. So Toby, we're coming to the end of our interview.
I can ask one more before we go.
I'm sorry.
No, it's fine. Because it's, no, don't worry, Janette.
Okay.
It's the question I wanted to ask you, Toby, about advice to give to younger lawyers. So what advice would you give to younger practitioners who are looking to get arbitrator appointments in particular?
So the first thing is actually getting into the field for younger practitioners. And that often is quite a difficult thing. It's competitive, but I do think that there are many more opportunities nowadays than there used to be to get into the field. Getting into the field as an arbitrator is of course even more difficult. And I think there are a number of steps that young practitioners can take. The first one of the best things you can do is to, if at all possible, get a role as legal secretary to a tribunal. The more you can do that, in fact, the more you get experience of the tribunal role. That is something that one can do nowadays by pushing oneself on institutions and by getting known amongst other practitioners who are active arbitrators that you're available to be a legal secretary. People do that at any age. Some people do it as quite senior lawyers, actually. I think that's one very important first step. The next thing is to get on the radar of those entities or people who are looking to appoint. So that's either going to be parties and their lawyers, or it's going to be institutions. Getting on parties' radar is not easy, but the field now makes it a little bit easier because of the huge number of conferences that we have almost on a daily basis somewhere in the world. A lot of those are now accessible online, but the best thing is, if at all possible, to attend conferences, to get to know people, to do what is known as schmoozing, because the more that you can actually get to know people, the more they may think of you when it comes to appointments. If they don't think of you, then you won't get those appointments. On the other hand, for institutions, there are mechanisms available for young practitioners to take on small cases. And the thing to do is to really contact those institutions and try and get on what are reserve panels. So for example, the SIAC in Singapore has what it calls a reserve panel for small cases, for arbitrators that have limited experience or sometimes no experience. So I think there are facilities and mechanisms available. Ultimately, I'd say don't give up. You have to keep pushing. It doesn't happen quickly, but when it starts to happen, then it becomes, in a sense, self-perpetuating, because once you've had one appointment, then often you advertise that and you'll get more appointments.
Thank you so much, Toby. Wonderful advices. We just had our first.
Yes, I was about to say, I'm glad that you got that question in
Yes.
because we just had our tribunal secretary training.
Yes, last
Perfect.
week.
Very good.
Spoke to Tribunal annually, and this is what we were telling the participants, because we had counsels from law firms, junior associates, and there's no seniority. You would see very junior lawyers and very senior
Yeah.
lawyers having that.
Absolutely. Absolutely. And I would say also, being a legal secretary it's an incredible training for an advocate, as well as if you want to be an arbitrator, because there's nothing that compares to sitting on the other side of the table and listening to counsel to actually know what works and what doesn't work for an advocate.
Yeah, and hopefully get inspired.
Yes.
Yeah.
Yeah.
Thank you, Toby.
So now, what I was dying to ask you, Toby, what do you do for fun?
That is the hardest question you've asked. So I have a long list of things that I do when I'm not working, and often they are things that I never do because I'm rarely not working. But when I'm not working, I have to say I play the cello badly. I am a keen photographer. I actually come from a family of photographers.
Okay.
And I am I'm quite keen, although appearances may not reflect this, on exercise. So I actually do quite a lot of cycling, and I have done something which I promised myself I would never ever do. And that is, I have become what's known as a mammal, which is a middle-aged man in lycra.
Okay. I did not know this
Okay,
one.
okay, I did not know this.
But it's necessary for cycling.
Cycling kit in a way that I thought I would never do. But yes, so that's what is on my list.
Great, great. Do you have a theme song? This is another question that we usually ask. A theme song that gets you through the day.
Oh my gosh. I don't have a theme song, but I do play a particular kind of music to get me through the day.
Right.
Which is I play very fast Baroque music.
Okay.
That is my key to keeping going.
Yes.
So which one in particular, like Bach or? Yeah.
There's Vivaldi,
Okay.
but only the fastest bits, and I'll play it and replay it.
Oh,
And
nice.
get into a slightly demented state of typing fast to Vivaldi.
Oh, okay. I'm imagining Toby
Yeah.
listening to Vivaldi.
Thank you so much for sharing. And we look forward to you joining us in BVI. Hopefully you'll bring your cello so you could play for us.
Yeah. Thank you very much. I'm not sure I would wish that on anybody, but thank you for the invitation.
All right.
Thank you so much, Toby.
Thank you.
Thank you, Toby, so much for joining us here on Arbitration Life.
And for more Arbitration Life, please be sure to hit the subscribe button and to follow us on LinkedIn, Twitter, Instagram, and Facebook at Arbitration Life.